Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest is Scott Hazlett, and Scott is a California attorney and CPA who practices in the areas of taxation, real estate planning, financial problem resolutions, and 1031 exchanges. He's a certified specialist in taxation law, California State Bar Board of Legal Specialization, and he's also a qualified intermediary for tax-deferred exchanges. Scott previously worked with Price Waterhouse and was an investment executive with Merrill Lynch. He graduated from Taft University School of Law in 1996 and set up his own law firm. Scott is a past president of the East Bay chapter of California Society of CPAs, and he teaches continuing education courses related to real estate and 1031 exchanges for CPAs. In the past life, he was a sports writer covering Major League Baseball, National Football League, and other sports. So thanks for joining me, Scott.
Thank you. Thanks for having me.
Okay, so today, Scott and I are going to be talking about tax planning for real estate change of ownership in California. So if you're in California and you are watching this, you can sort of count your lucky stars that you don't have to worry about this stuff. On the other hand, it's a great break for us, Proposition 13 here in California. But as we get into this, remember we only have a brief time, and so this is just an introduction to a complex issue, and it's to help people become aware of these for further discussion with an attorney or other tax advisor who's familiar with them. And this isn't an issue that's discussed regularly in the tax consulting field. In other words, when we CPAs, or when we went to school, at least when I went, they didn't have a class. First of all, it didn't exist, change of ownership in those days, and I'm not sure how much that they've got available now. There are continuing education classes that are occasionally presented in this area, but it's really sort of a special topic that a lot of people aren't so aware of. Don't you agree, Scott?
Oh, totally. Yeah, and I do teach in one of the classes. I have a significant segment dedicated to this, but it's unique to California, and but we are a big state, and it's a revenue issue, and it's a hot button issue, and it's politically sensitive, and it's always under attack. The Prop 13 system. But it is a very unique animal of all of our 50 states. So, but it's interesting. It's interesting, and it usually isn't thought of first thing out of your mind in conjunction with other types of planning transactions. So it's interesting to see the effects of it.
Yeah, it's one of those things that people maybe do other types of tax planning, and then they and maybe they even go ahead and they do oops.
Correct.
Because suddenly they're getting a letter from the county assessor or something. So maybe we should just hit some highlights here. Why should California residents who own real estate be concerned about change of ownership rules when they're doing their income and estate planning?
So I think it's good to step back to understand the system just real briefly.
All right.
So in the early 70s, California had this system, much like every other place in the United States, where the assessor goes around annually and says, okay, your property is worth X amount, and the tax rate is 1 or 2%, and they would send you a tax bill based on what the assessor came up with. And of course, California real estate during that time, late 60s, early 70s, escalated in values. And so somebody might have had a property tax bill for $1,000 a year, and then all of a sudden they open their next year's tax bill, and there might be $1,400, which was in those days a lot of money. I suppose it's still a lot of money now. Seniors were the biggest ones that it hit because they have fixed incomes generally, and their taxes, they kind of expect things to sort of go up a little, but not a lot. And when they start seeing big increases in what amounts to a mandated item, it created a backlash. So the Jarvis scan came in, and there's a big rollback to make sure we have a system where seniors aren't hit, and families and so forth and so on. And now, in hindsight, the way California real estate has truly escalated in value, without these rules, property taxes could have doubled and tripled under the old system. So these rules have been very effective in keeping property taxes in check. So the basic framework is that if you owned a property on March 1st, 1975, it was assessed at that date And then the law allowed, if you owned it for the rest of your time, there would be a little bit of increase, up to 2% per annum based on inflation. And so it would be a little bit, not that big of a deal, et cetera, et cetera. And then the other feature was, and how this was sold to the taxpayers was, the opponents of this said, well, this is going to stunt the revenues, but the proponents said, at some point we're going to transfer properties and then it gets reassessed on cost. So I bought a property in 1960 for $10,000, and then I lived there until 1990, and I sold it for $1 million. The new guy would pay taxes on $1 million, even though I was paying on this lower base from 1975, and it was intended that it would eventually roll over and it would all go away. Well, it didn't really work that way, but we still have this system. And in addition to that, after this was put into place, there were these exceptions that came about. The principal exception is transferring intra-family, a parent to child. It's sometimes called Prop 58. So that is a big deal when you talk about estate planning. So let's go back to estate planning. So estate planning is a transfer of wealth. And oftentimes estate planning will be a transfer of, say, investment property or personal investment real property, or sometimes personal real property, from a parent to a child, either under a will after the parent dies, or sometimes it's during life, and there's a bunch of federal estate or federal gift tax considerations to do that. And that's a whole different program, but there can be some significant advantages in transferring those interests during life, or certainly they would transfer under a will or under a living trust after death. Well, the problem is that transfers, generally speaking, are a change of ownership, which triggers a reassessment. So property might be assessed for $100,000, but if it's worth $1 million today, the minute someone dies and leaves it to somebody else, the thing gets reassessed to $1 million. So property taxes go up significantly at that point. So enter the exceptions. The principal one we're talking about, of when a parent transfers real property to a child, there's two rules. One is you've got a principal residence transferring to a child. The old base is retained, and there's no increase, there's no reassessment. And then there's another rule that covers all other real estate, not principal residence, which is $1 million in assessed value can be transferred from the parent to the child. So right. So you have to watch out for it, because there's some real fancy techniques that either destroy those advantages or fail to take advantage of those advantages.
Yeah. So we should also mention that grandchildren can also qualify for the same exclusion as children, but they have to meet special requirements.
Right. The principal requirement on that is if the intervening generation has died.
Right. So both parents have to be gone.
Correct.
So I had this that I was dealing with when my sister passed away, and I thought, she's gone, and shouldn't be a problem related to the grandkids, because if I look down the generation, the problem is that my brother-in-law was still living.
Correct.
So
and even though he's not blood, he's still part of the system.
He still is. So
That's correct.
The other exception, I don't know if you mentioned it, so maybe we should just reiterate, is what about spousal transfers?
Well, a transfer from one spouse to the other. So this is, I get married, I own a property, and then in consideration of the marriage, or just because I'm a great guy, I add my wife onto the title. So that's a transfer, certainly, of an interest, but that's not a transfer that triggers a reassessment. And there's no dollar limits on that. That's a special relationship.
Okay.
And that would be true also if a husband died and left property to his wife, or those types of things, any sort of transfer. One thing I want to mention also, when you're talking about a transfer from the spousal, in one way, and also the parent to child transfer, it can be a child to parent transfer. That's one thing that people forget about. Because sometimes we have children that are really wealthy, although they might not have a low base, who knows. But the other thing is that the transfer can be on a purchase, it can be on a gift, it can be on a bargain purchase where it's partly given and partly purchased, it can be during life, or after death. It can be partial. There's a lot of different permutations on this. So it isn't necessarily, doesn't mean there's got to be a gift and the donor is giving up real value. They can get money in return. So.
Yeah. So these things sound simple as we talk about them here, but there's all sorts of details, in a sense, that folks were really sort of glossing over, including like transfers or partnerships and other things. Oh my gosh! So the permutation, like we said, you have, in many cases, you have to diagram these things.
Absolutely.
And look at what the percentages is in order to see if there's in fact a change of more than 50%. And if you're just under the, if you're just there, if you're 49%, you can be okay.
So one of the things that happens oftentimes in estate planning, what we'll see is the donor or the parent or the grandparent will transfer property into a newly created entity like a limited liability company. And then the technique for federal transfer tax purposes, nothing to do with this, but the technique to save taxes, federal taxes, is to give away membership units of the limited liability company. So indirectly, the child is getting the real estate, but through the auspices of this LLC. Those transfers of those units don't necessarily trigger a reassessment, but when you reach certain thresholds, and you mentioned the 50%, the code section is 64C and D. If there's a transfer of more than 50% of the company, or a change of control in the company, then the entire property can take an increase in value, even though the senior generation may, in effect, retain some of the property. They can get hit with a reassessment on the full value. So very, very tricky. And sometimes, frankly, there's a trade-off, because you can see a compelling reason to do this, or some business or tax reason to do this, federal tax reason, and then you say, okay, we're going to do that, and we're going to save a bunch of money over there, but recognize that from now on, instead of being $2,000 a year in taxes, it's going to be $25,000 a year in taxes and higher, and that's just a side effect that comes with it. So that's why it's a really an important planning consideration.
Right. So I'm just going to throw this to you, and if you want to sort of bypass on it to some degree, that's okay. But what about when you've got these family exclusions in mind? Can this affect your distribution planning for an estate or trust to be structured to avoid reassessment?
Yeah, so here's a real common thing, and I've had a couple of cases like that just recently. So we've got mom and dad, and they've got 3 children. Okay, just had a case. In fact, I just got an email, happily. I mean, we went through a lot of rigmarole to get to a happy outcome.
Okay.
So mom and dad owned a property in San Francisco. Residents. They lived there for 9,000 years. I mean, they were there forever. And they weren't in the gold rush, though.
Okay.
So anyway, there are 3 children, and it was quite apparent that the daughter, there were 2 boys and a daughter, it was quite apparent that the daughter and her husband were the logical successors to this house. But it was also quite apparent through the will, or the trust, or as the case may be, that the parents loved the children equally, and they basically said, when we die, we're going to give the estate, the totality, the money, the stocks, the IRA, the everything, we're going to give it in 1/3 shares. We're not going to specify anything in particular, but there's going to be one big value, and we're going to give 1/3 shares to each of them. So some are going to get, maybe you split everything up 1/3 each. And it was possible under that will. Mm-hmm. Now, the will says that whoever's doing the distributing is a trustee or an executor. They have the right, it doesn't always say this, so it's make sure that's in your trust or your will. They have the right to give one person real estate and another person money, or to give them the cars and give them the baseball card collection. But basically, you want to reach this 1/3 value in my example of equal value, but different stuff to equate to the value. So the daughter is looking at the house and saying, their assessed value, this $2 million house, and their assessed value is $200,000. And they're paying not very much. They're paying, like $3,000 a year in taxes. And if we had to buy a $2 million house, we'd be like $27,000, $28,000 a year. That's $2,000 a month. That's a lot more money. So wouldn't it be nice to be able to take that over? Now, the mistake sometimes, and it's too late for a guy like me to fix it, but the mistake is they plow ahead and they just give everything 1/3. Well, what ends up happening there is the daughter on her 1/3 retains 1/3 of the old assessment. And then she turns around and says to her brothers, hey, I want to buy you out. And then they transfer their interest to her for money or for some sort of consideration. And it's not because of the purchase, but it's the fact that it transfers from the sibling. There is no sibling to sibling transfer exception. There's only a parent to child transfer exception. So she gets a step up on 2/3, and so she's somewhere in the 18 to 20,000 range on property taxes, and certainly not a happy result because she's going to live there for a long time. But there's a way to make it so that she gets the house and she gets the old assessment, and that's even true where the house is a bigger component. Let's say they had a $2 million house and they got $1 million of other stuff. Well, there's certainly not enough money to pay the other people. So you have to make financial arrangements to make sure they get paid equally and that she gets the asset wholly. Now, the story goes on. We actually filed a petition with San Francisco assessor. I did this twice recently. The first time, we ended up with a really good guy at the assessor's office. Oh yeah, sure, you can do that. And he sent us a letter. Fantastic. Mm-hmm. And then we just did what he said. You know, we laid it all out. Here's what we're going to do. And they said, yeah, fine. That's fine. The second time, they sent us to the Board of Equalization. So they said, we don't make an opinion. So they sent the case to Board of Equalization. Now we got a good contact there. Hey, we're going to do this. Okay, if you do this, fine. And then they send you an advisory. Just follow these steps and you will get your desired treatment. So the happy result for both of these clients was that they have very valuable real estate and a very low tax base because they followed the protocols and the rules.
Right. So this is why, you need to be very careful when you're dealing with these situations. And there are an awful lot of people, frankly, that try to self-administer their trust or to shortcut this process.
Yeah, absolutely.
And so when you do that, then you'll find in many cases that you stubbed your toe.
Yes.
And that you could have saved your family a lot of money by going a different direction.
Yeah. So there's another thing I want to mention too is sometimes we run into situations where we've got a family, let's say the mom and dad have developed a huge portfolio of real estate. They've got commercial buildings and apartment buildings, all this stuff. The rules say, and unfortunately the way the statute's written, it's poorly written. They call it full cash value, which doesn't mean full cash value. It means the assessed value. So they bought the real estate a long time ago, and it's $50 million worth of real estate, but the assessment is say $3 million. Mm-hmm. Okay. Now, what that means basically is that 1/3 of the property can pass under the old rule, but 2/3 of the property will pass and have an immediate step up on basis or step up on the assessment. So the trick in that situation is to ask the transferees, the children, which properties are you going to keep and which are you going to sell?
Right.
Because if you say, okay, I'm only going to keep this $15 million piece here out of 50, you say, well, that's a slam dunk. I'm going to assign all of that exemption to that one property because that's going to live forever, or at least till I pass away. And the other ones I don't really care about. I may pay higher taxes a little bit, but then as soon as I sell it, the next guy's going to pay anyway. It's sort of out of the system, and it kind of goes away. So there's a pick and choose mentality as well on this.
Yeah, good point. All right. Well, what about many people are using these living trusts now, mm-hmm. and these trusts in many cases can continue. Can you maybe project out, for some scenarios related to that where, suddenly you may be dealing with a reassessment that maybe you didn't anticipate? Or?
Yeah, it's possible. Ordinarily with a living trust, it'll say, my trust holds these properties, my principal home and maybe a couple of rental properties and so forth and so on. And the rules are very clear that the transfers are from parent to child, but the rules also provide that a trust, which is an estate planning mechanism having really nothing to do with taxes or anything else, it's just a medium. And so the trust itself is disregarded. That's one issue. Now, there's a second, more advanced piece of estate planning when we start using irrevocable trusts, things like lead trusts or remainder trusts or trusts that are set up in such a way that so-and-so gets income for life, and then when that person dies, it goes to the next person, and it's really complicated. At some point, the interests sort of devolve not into real estate, but into trust interests, which are not really, it's sort of like the partnership or the company thing we mentioned a minute ago. So those types of interests are not eligible for these reassessments. And at some point, the trust ends, and then the ultimate beneficiary is not a child, and therefore this disregarded rule on most living trusts is in fact not in effect, and all of a sudden you get whacked with a huge reassessment on the termination. Now remember, in California, you can't have a trust that goes on for 1,000 years. There's something called the rule against perpetuities, way beyond the scope of today's program, but when you get involved with that sort of planning using South Dakota or Delaware, those types of things, then you have to, once again, take into account there's going to be possibly a side effect of the property tax level for our California real estate.
Okay.
So the one other thing I wanted to mention, I don't know we've touched on, but I wanted to briefly digress into so-called Prop 60 and Prop 90. Is that where you were headed next? Did I read your mind?
No, but you can go ahead and chat about it for a couple minutes.
Okay, so one of these exceptions, remember the general rule is whenever property transfers, you have a reassessment. So a very common lifestyle situation is where someone gets up, in this case, let's say above age 55, which is a threshold, and they say, we've had our 9 kids and we had a big house in Santa Clara, and boy, there's a lot to clean, and we want to sell, and the guy from Google wants to buy it, and it's just going to be fantastic. So we want to downsize.
Right.
So now the house itself is worth $3 million, but since we bought it in 1962, the assessment is $200,000. So we're paying low property taxes, and we want to buy something in San Jose, but anything we like is about $1 million, and so we're going to go from this 200 assessment to $1 million, and it's sort of like we're trapped by our property tax level. So a rule was created, which is commonly called Prop 60, where if you change residences, you sell a residence in a county, and in the same county you buy a new residence, generally speaking equal or lower in price than what you sold the old residence for, then you can take your old assessment with you one time. And of course, this gets into, if you remarry later in life, you always want to check and see if your new spouse has used their one time, because you only get to use it one time per couple. So I sell the property for $3 million. I have assessment for $200,000. I buy this property over here for $1 million, like a condo or a townhome or something. Ordinarily, I'd pay $1 million assessment, but because I had $200,000 here, and because this is my principal residence in both cases, I can transfer the assessment over here, and I have a new assessment. It travels with this, so forth.
Right.
There's a parallel concept called Prop 90, and Prop 90 is not universal, but you can go on the State Board of Equalization website or the county website. Santa Clara happens to be what's called a Prop 90 destination county. LA County, Ventura County, some of the other counties, there's about 9 or 10 counties.
Yeah, I think it's sort of gone down in number over the years.
Yeah, well, surprisingly, El Dorado was added about 6 years ago, so it's changed over the years. But you can actually move to a different county in some cases and have the same treatment. But you always want to check first to see.
Right, so they have to have agreed to participate in that, and it's very optional to the county.
Correct.
So anyway, yeah, so those are good ways to avoid reassessment for seniors when they do want to move, and I've been dealing with that recently.
Right.
Okay, so we're getting a little shorter on time. I guess let's just highlight this. What should a California real estate owner do if he or she receives a letter from the county assessor's office inquiring about a possible change of ownership?
Immediately call somebody. That would be. The assessor is very friendly, but to retain your legal rights, you need to file some sort of appeal, and the deadline is typically 60 days from the date of the letter. So you get it. Today's May 23rd. 60 days from today is July 21 or something, or July 22. So you have to have something postmarked on that date. And it's a simple one-page form. It doesn't have to be rocket science, although you probably should get somebody to help you with it, a CPA or a tax attorney, and say, okay, you're saying that there's a reassessment here. The old assessment was 200,000, the new assessment's 2 million. We protest. We don't think it applies, number one, because of an exception, or number two, you've gone, it's not really 2 million, it's more like $1 million, or there's some genuine dispute about the new valuation. But the main thing is get something on file, because then leads into a whole battery of rights that you have to continue the appeal to the county assessor or to the county board of supervisors, as the case may be.
Right. So we're about out of time again. Maybe you can talk just for a moment or two, though, about some of the reporting requirements.
Yeah. So one of the things is that a real classic situation is somebody dies and they have a living trust, and it's typically administration doesn't really start right away, and it might be put off for 60, 90, 120 days. It might be several months before things get going. There might be a probate, there might be just a trust administration. But because these transfers are time sensitive, you have to, number one, you're not automatically granted an exception. You have to apply for it. So this parent-child thing, you have to apply for it. It doesn't automatically happen. You have a 3-year time frame. So the key is when there's a death, and there's real estate involved, you need to get with the county and say, hey, this person died, there's an administration going on, we are reserving our rights to claim exemptions from transfer. We'll get back to you. At a minimum, you have to tell, because if you don't, then you could lose valuable rights and you could get clobbered at a later point.
Right. So there are a lot of notice requirements, but one of the things, like on business tax returns now, there's a box.
Correct.
And they ask each year, has there been a change of ownership?
Correct.
Related to this entity?
The state's inquiring, no question.
Right. So they're watching, and of course, they're watching for any change of title that happens with the people that handle title, the recorder's office, and so forth. So they're watching very carefully because they're very interested in the revenue. Folks, we're all out of time, so thanks for joining us. Thanks for joining me, Scott. See you next time, Financial Insider Weekly.